heard about this, but Dignity Health is one of the largest health providers in this area.
Heard about it.
2 weeks ago, Dignity Health entered into a settlement with the U.S. Attorney in San Francisco Federal Court because what they were doing in Northern California, Nevada, and a few hospitals in Arizona is Dignity was just confused by the fact that some patients were inpatient, that means they're in the hospital, and some patients get treatment out of the hospital, that's called outpatient. And if you're in the hospital, inpatient, out of the hospital, outpatient, Dignity was confused by this difference. And so they billed all the outpatient services they provided as inpatient services to TRICARE and Medicare, which means taxpayers, we were paying for this, to the tune of $46 million. And when they got caught, then, and it was a whistleblower who used to work for Dignity, who blew the whistle on them and got the federal prosecution going. And when they got caught, they said, okay, you got us. After the lawsuit was filed, after they went through discovery, and they realized that they were going to get nailed, then they paid back what they had stolen. So that's what we do in the United States. When we catch a big corporation or a healthcare provider stealing from the taxpayers, we make them pay it back. So
They
that's,
don't have to go to prison.
and if you or I steal, we go to prison. But if a corporation or a health provider steals, then they have to pay it back. So that's $46 million was, excuse me, what they got caught stealing this time. And no telling how many times other healthcare providers or other insurance companies have been doing the same thing and haven't got caught. It just happened to be this inside whistleblower either retired or got fired or whatever and decided to go tell the feds. So when you have profits like that of $46 million that might have, you know, they were stealing from the government, that's probably a drop in the ocean compared to what the insurance companies and the healthcare providers are stealing from Medicare and TRICARE. TRICARE is the federal program that pays for veterans for their healthcare, and veterans, the people who rely on veterans for their healthcare. So at any rate, when you have $46 million like that, that's just a drop in the ocean. When we had Proposition 46 on the election, in the election last month, or this month, they, the Kaiser put up $10 million by itself, which was twice what greedy trial lawyers were able to script up through the entire state of California. And we had fundraisers. I was getting hit daily, being asked for money for the Pro 46 campaign, and Kaiser by itself outspent us 2-1, and that doesn't even count all the other healthcare providers. So, with that kind of an idea, the hardest case that we face as attorneys, trial attorneys, is a medical malpractice case because of MICRA, which was passed in 1978. There have been several attempts to change MICRA. Proposition 46 was the last attempt, and they probably didn't go at it in the best way, but it wasn't the trial attorneys who brought 46. It was a guy whose 2 children were killed by a Kaiser patient who was going from Kaiser to Kaiser and getting drugs. And even though Kaiser has a computer program, they didn't check and catch that she was getting drugs at several places. She was so high she didn't even realize that she ran down these 2 kids and killed them. And so their father, a guy named Bob Pack, started this Proposition 46, and he was the main force behind it. And what he wanted to try to do is to make sure that this database was maintained by the hospital so that patients wouldn't be able to go from hospital to hospital and get drugs. And he also wanted doctors to drug test, and then he also wanted to take the lid off of the damages that you get in a medical malpractice case. They were set in 1975, or 78, at $250,000. And maybe that sounds like a lot of money, but it's not a lot of money when you consider that the doctors and their insurance companies have an unlimited amount of money to put on the other side. And plaintiffs' attorneys are limited by statute under MICRA as to how much money we can make on one of those kinds of cases. Christian?
Do you think it would have been better to split it up? I thought that was a big challenge with that bill when I read it, was the fact that they put all those things together. Because I think if they put the doctor part separate from the the medical malpractice, I probably would have passed the medical malpractice.
Well, actually, we've tried to change the medical malpractice law, we've been trying
On its own.
in every election on its own. And the insurance companies and the doctors' companies, they always are able to cast us as greedy trial lawyers that are trying to get more money. Well, we scraped every penny we could out of the state of California. We came up with $5 million in this Pro 46. Kaiser put up $10 million by itself. We were outspent 10 to 1 by the hospitals and doctors. But I have a case right now that is a medical malpractice case where this woman was involved, involved in an auto accident. And so she had terrible back pain as a result of this auto accident. And she was a Sutter patient, and she lived in Dixon. And so she went to the Sutter facility there, and they would give her drugs, painkillers, like it was candy. And they have a system there where they know exactly how much drugs are being administered. And it's a system-wide system, so that any Sutter that she goes to, they know where she's getting her medication. Well, she was constantly going in because she was in a lot of pain, and they wouldn't do anything like give her an MRI or give her any other treatment other than drugs. And so finally, the doctor was sick and tired of this woman coming in and bothering them every day asking for medication. So the doctor injected her with 4 milligrams of Dilaudid. Now, she wasn't that big a woman, and they also knew that she had other medication that they prescribed for her. And the doctor pat her on the head, go home now, you're fine. And the woman promptly went home, and 4 milligrams of Dilaudid will kill a horse. And she went to bed, laid down on the couch, and never woke up. So that's our case. She has 2 children who are in college, and they're the people bringing this case. And we submitted the information to her insurance company, to the doctor's insurance company. And the doctor's insurance company told us to go pound sand, that they didn't think that there was anything wrong with giving a 4 milligram injection of Dilaudid to a woman who already had drugs in her system, and it killed her. So we're in litigation right now, and they can spare no expense, and they're spending all sorts of money to hire experts to say that it was all this woman's fault, that she got that injection of Dilaudid that killed her. And it wasn't the doctor's fault at all. So it's a very difficult case, and it's a case that I don't think many attorneys would take, because it's got that $250,000 cap on it. No matter how much damage the girls that are her kids can show, they're capped out at $250,000. So then attorney's fees are capped out. We can't get a third, not even a third of the recovery, because micro limits the attorney's fees. So other cases that have come in, I may have described the Kaiser case, where Kaiser, guy came in with an inguinal hernia, and he's a janitor in a school, kind of a young guy, and he was out playing football or something on the weekend, and he got an inguinal hernia. So he went in to Kaiser, and they diagnosed an inguinal hernia, and they had to do a surgery to fix it. And when they took him in to do the surgery, they decided to take his appendix out. And so they took his appendix out, and they didn't fix the hernia at all. And so he had to take a month off work to recover from the appendix surgery, because they didn't do that great a job. And then he came back and said, hey, I still have this inguinal hernia. So then they had to perform the inguinal hernia. Now, that guy came to me, and I was about the 4th or 5th attorney that he talked to, and nobody will take his case. Kaiser has mandatory arbitration, and so you have to go through their system where they have an arbitrator that they pay, and the arbitrators know that if they rule against Kaiser, they're never going to get another case. So they never rule in favor of the plaintiff, or if they do, the damages are going to be very low. So if you are a Kaiser patient, you probably don't even know this, but you've given up your right, your constitutional right, to a jury trial, because you have to go through mandatory arbitration. Mandatory arbitration is increasingly prevalent in insurance policies, and so I would check your insurance to see if you have mandatory arbitration, because you may not realize it, but you gave up your constitutional right to a jury trial, and to a jury in front of, or a trial in front of, a court system, because if you have to go through their mandatory arbitration, you're going to end up in front of one of their judges who is not going to give you anything. I've had cases against Kaiser. I had a case where a woman went to Kaiser and she was in her 70s and she has a little bit of dry eye condition going on. And so she went in and they actually blinded her in one eye in giving her the treatment that they were trying to fix her dry eye. And so she came to me and I said, there's no money in this case. It'll cost me more to hire the experts to testify in this case than what we will recover because it is a Kaiser case. And I said, sorry, I can't help you. And the day before her arbitration hearing, she came to me and said, will you please just come in and, I don't want to go to this arbitration by myself, will you at least just come in and when they talk legal lingo, you can help me. So, you know, I didn't want to do it, but I thought, this poor woman is just going to get chewed up and spit out in the Kaiser arbitration. So I went in and they called the doctor who had screwed up and blinded her in one eye. And I cross-examined him, and I got him to admit that it was his treatment that caused her blindness. And the arbitrator, we got all done, and the arbitrator turns to me and he says, where's your expert? I go, you know, she couldn't afford to hire an expert, I couldn't afford to hire an expert. We don't have an expert. And I said, but the doctor testified that he malpracticed. He admitted that he malpracticed. And the arbitrator said, nice try. And he defensed us right then and there. You get a big fat 0. Even though the doctor admitted it in the hearing, you get a big fat 0 defense award, and told the woman you needed an expert. And of course, I'd already told her that. You needed an expert to win this case. And since you didn't have an expert, you just lost. And
how much does an expert witness charge?
They will charge you anywhere from $1,000 to $10,000 an hour. And so often you can have $100,000 in a case. And that's another reason why I do personal injury cases, auto accidents and other personal injury types of cases. Medical malpractice cases, when you have to put $50,000 to $100,000 into a case, why take those cases when the damages are limited? It just doesn't make any sense to take those cases. A friend of mine was talking, he does a lot of medical malpractice. He had a case where his 7 and 8-year-old kids on a rainy day were out in the garage and they found Dad's golf clubs and they were screwing around with the golf clubs, and one of the kids swung the golf club and hit the other kid in the head. So it opened up a big gash in his head, and so they rushed him into the hospital, and they didn't even see, they saw a physician's assistant, they didn't see a doctor. And at the hospital, ER, they sewed the kid up and sent him home. Well, the problem is, before the kid left the ER, he started throwing up, and his eyes were, he was having a hard time tracking. And anybody who knows anything about triage knows that the kid had a closed-head injury. And all they did was sew him up and send him home. Well, the kid went home, about 3 hours later, had a brain hemorrhage and died. So, by virtue, if they'd kept him in the ER, when his brain would have hemorrhaged, they would have had immediate medical care and they could have saved the kid. And they should have. The standard of care, everybody agreed, the standard of care is that when you have a kid who's throwing up, or anybody who's throwing up after being hit in the head, you don't just send them home. Well, no attorney will take that case, because what is a 7-year-old worth? A 7-year-old isn't worth anything. And so $250,000 is your cap, and no matter how much the parents of that kid will say that they lost the kid and they missed the kid, it's not worth enough. And to hire the experts to put that case on would make it impossible. So those parents tried and went to attorney after attorney, and nobody can take that case. There are cases that are just amazing that the American College of Gynecology sets out standards. And I had a case where a woman who was in labor went into the hospital, and they had, the American College of Gynecology says that when the fetal heart monitor strip reaches a certain blood pulse, that you have 3 minutes or 4 minutes or 5 minutes to get the kid out of there. That's the standard of care. Well, the American College of Gynecology puts out a standard that says it's 30 minutes. in this particular case, we had the medical records. The kid flatlined at 60 beats per minute, 30 beats per minute, whatever it was, and for 29 minutes, so that the baby was born blind, profoundly retarded because of oxygen deprivation, and 3 days after the baby was born, it died. And so I hired doctor after doctor to give me the standard of care, and every doctor would say, I would get that kid out in 3, 4, or 5 minutes because you have brain damage when you're deprived of oxygen in 3, 4, or 5 minutes. That's my standard of care when I practice in the ER or in the OBGYN. But the American College of Gynecology standard is 30 minutes, and so all the doctors told me, you're going to lose. You know, I can't help you, I can't testify. So that's another situation. Medical malpractice cases are the toughest, and the laws and the insurance companies that defend the doctors are diabolical and spend all sorts of money to not pay a claim. One other aspect about it, about the MICRA, is that if you do, one of the better cases to get are these they're called bad baby cases, where the doctor doesn't get the baby out in time and the baby suffers brain damage, and then the baby has to have care for the rest of its life. That doesn't have the $250,000 cap because those are actual damages that the baby will suffer over its life. So those cases might be $10 million to take care of the baby for the rest of his life. So when the medical malpractice attorneys look for these bad baby cases, well, I've had bad baby cases in the past. The bad thing about bad baby cases is that after you win the case, after you fight with the insurance company and you fight with the doctors, and they'll tell you the most outrageous things about the standard of care, and after you win the case and you get your $10 million award, then they can go in to the judge and get an order from the judge that they don't have to pay until the baby needs the care. So they'll say, okay, we're going to give you $100,000 this year for the baby's care, and then as far as the rest of the $10 million, we'll wait until you need the money. And the judges order this. And so what happens is then the baby is put into a Medi-Cal facility, whatever the insurance company deems that they can pay for at that point in time, and the judge goes along with. So the baby has a shortened lifespan as a result of the care that they're able to pay for. And then as a result of that, the insurance company, once the baby dies, is off the hook.
And do they get to keep the rest of the money?
They get to keep the rest of the money, no matter what the judgment was. So the law in MICRA is a terrible law. It was passed back in 1978 because the insurance companies had some bad investments. The economy went down. There was actually testimony in the legislature that they had $30,000 worth of medical malpractice claims in that year, but the insurance companies lost $18 million because they lost that money on their investments. They didn't lose it on the claims. So what they did is they passed the law, and they marched on Sacramento, and the doctors' wives came in and said, we can't afford all these medical malpractice premiums. And I feel for the doctors in having to pay the premiums because I have to pay for legal malpractice premiums. But I don't have the benefit of limiting the attorney's fees of the attorney who's going to sue me for malpractice. I don't get the benefit of paying them when I want to. I don't get the benefit of limiting the damages to only $250,000. All those things deprive us of the right to go to trial or to have a medical malpractice case. So, any questions?
We're all sitting
I'm
here
so
like,
impressed.
"Ah."
I know. We should
So
change
you don't like
our
kids?
insurance from Kaiser. It's the bottom line. If we have Kaiser, we'll try.
Well, Kaiser's cheap as a result of, and sometimes, I know people who have Kaiser, and they love their Kaiser.
It's one of those
They
things.
love their, I don't. And I can tell you from a personal injury aspect, Kaiser, if you get in a car wreck, for instance, and your neck is killing you, and you've got shoulder pain, and Christian is saying, we need an MRI to see if you've got a herniated disc in here. Everything looks to me like you got a herniated disc. Kaiser will never give you that MRI until you go through all their steps. You've got to go through the physical therapy. You've got to go through their chiropractor. You have to go through seeing a neurologist. You have to go through injection therapy. You have to do all these things before you actually see an orthopedist. And I had one lady who, she's a repeat business because she keeps getting tapped. She gets a little rear ender here on Court Street or something, and it totally disables her because Kaiser would not operate on her neck. And we went outside the Kaiser system, got an MRI, talked to an orthopedic surgeon. Orthopedic surgeon said, she's got a herniated disc, I'll operate tomorrow. How's she gonna pay for this? Well, she's Kaiser. I can't take Kaiser. So she did not get the surgery, and so every time she's involved in a little fender bender, she's back in to see me. Well, when she went to Kaiser, the doctor, after 6 months of going through all these hoops, the doctor in the room stuck the MRI into the view box, took a look at the herniated disc, and he says, oh, we don't cut on these, this is too small, and walked out. He spent 10 seconds with her. And so that woman is going through all sorts of pain and problems, and she finally fell out of care. And that's another thing that they hope, is that you'll lose your insurance, so then you're somebody else's problem. And you know whose problem they go to? Medi-Cal. So you and I end up paying and subsidizing the healthcare providers like Kaiser, like Dignity, and we are the ones that end up paying for these people through Medi-Cal and Medicare. Christian?
Kind of a quick follow-up question on the Dignity Healthcare thing.
Sure.
So with it, was it not found as Medicare fraud?
They were sued for Medicare fraud by the U.S. attorney.
But they settled it without being a Medicare fraud case or something?
No, they settled it by making restitution. And so, you know, nobody is going to go to jail in that.
And usually you would on Medicare fraud, because it is a felony.
Well, it's a corporation. Who are you going to put in jail?
Oh. So then the question is, were there any penalties placed on it? Or in what period of time before it was over?
I don't know the details. What happened, I caught it because Dignity released a press release that said this was inpatient, outpatient. It was very complicated and we didn't know. And then they asked the U.S. attorney for a statement, and the U.S. attorney wasn't prepared to make any statement. But then whoever wrote the article actually went and looked at the pleadings and saw that it was a whistleblower situation, $46 million, and it was what they had stolen. Now, in a whistleblower situation like that, the whistleblower got, I think, $6 million for doing that. It's a percentage of it, and the attorneys. And so we taxpayers took it in the shorts on that deal because $46 million was stolen, the cost of getting it back and all that. Yeah.
They should have at least had to pay for both the whistleblower and the 46 million.
But see, that's not the way we treat corporations in the United States. So anyway, yeah, I'm happy to answer any other questions.
Dignity Health, is that Woodland Health?
Yeah. Yes.
There's a lot of people over the years that have horror stories, and I go, I just sue for malpractice, but I guess
Sue
this
for
is why.
malpractice.
But I guess
Michael, take the case.
Find a lawyer to take the case.
Does that apply to dentists?
Yes. Yes. We have a case where a lady was dropped off of a gurney, and she was in the hospital, went into the ER, and they just didn't tie her down, and that's a medical malpractice case. And the nurse is the one who didn't do her job. It's not the doctor. And but we're limited by micro in that situation. So I don't even think that's a medical malpractice case, but there's case law behind micro where the doctors and the insurance companies want those cases to be micro. They don't want them to be in the regular run of personal injury cases where there's plain
Fall in
liability.
the hospital and you break your, leg because they had an open pitch.
That's a much better
Yeah,
That's like,
that's a much better case. That's a much better case.
Find a hole.
yeah.
I know, that's right.
That was negligence.
Jump in.
So anyway, thank you.